Welcome to GovCon Intelligence. I'm your host, Sam Lee. It's a solo episode today. I'm going to be going over SBA's proposed rule on changes to 8A eligibility. But that's not the only news that we'll be going over today. There's big news out of Department of War on the Small Business Bill of Rights. That's a good benefit to small businesses, but DoW is not really talking about it. But it gives a new avenue for small businesses to get information from DoW as well as to file complaints with the department if they have complaints. There's also been a reorganization within SBA. We'll go over that, as well as some fraud cases and cases out of GAO and Court of Federal Claims. I'll also take a look at the latest 8A data too on the suspensions and the number of companies in the 8A program. So thanks for joining us for this solo episode. I'll start with the proposed rule that SBA has put out on pre-publication today. So it actually getting published officially tomorrow, June 11th, and it'll have a 30-day comment period. So the comments will be due July 13th, actually, because July 11th falls on a Saturday. So we will get 30 days to process this. But it's really just a change to one rule. I think 30 days is a decent amount of time to figure out what's going on here. The proposed rule is called Reforms to Remove SBA's 8A Programs Rebuttable Presumption of Social Disadvantage for Individually Owned Firms Only. Reforms do not impact entity owned firms. Yes, they actually put that statement in the title of the rule. Reforms do not impact entity owned firms. So, very clearly, this only applies to individual owned firms, firms owned by individual applicants. This changes as the title suggests, the rebuttable presumption of social disadvantage for the 8A program. It could have been broader. We were potentially looking at changes that might occur for the economic disadvantage, for potential for success, maybe business activity targets within the 8A program. This rule does not touch those other areas. This proposed rule is only about social disadvantage. To get in the 8A program, you need to have social disadvantage, you need to have economic disadvantage, you need potential for success, you need good character. This rule is only about that first part. It's only about social disadvantage within the 8A program. And this comes after a 3-year period where SBA has been trying to grapple with the Supreme Court's decision in the affirmative action cases, the one about UNC and Harvard, students for fair admissions, the name of the case, as well as a district court case out of the Eastern District of Tennessee. That case was called Ultima Services. Ultima Services specifically dealt with the SBA's use of social disadvantage rebuttable presumption. The SBA goes through some of the history of that. Apparently, it came out in 1986 until its quote unquote demise in 2023, according to this case. And the rebuttable presumption of social disadvantage essentially said that there are 5 groups that do not have to establish their individual disadvantage. Right now, as many as you know, you have to write a narrative to get in the program. You have to say how I, as an individual, suffered discrimination or have social disadvantage. Under the rebuttable presumption, people in those 5 groups did not have to write that sort of narrative. The 5 groups were Black American, Hispanic American, Asian Pacific American, South Asian American, and Native American. So if you're in one of those 5 groups under the social disadvantage rebuttable presumption, you could just self-certify and say, "Hey, I'm in this group," and then you can get into the program under social disadvantage. You still had to comply with the other requirements: economic disadvantage, potential for success, good character, but social disadvantage was taken care of for those 5 groups. Since 2023, SBA has not used that rebuttable presumption. Instead, they've put in place a narrative process where individuals have to write up their own individual disadvantage. Why were you as an individual discriminated against? And then SBA reviews that narrative to decide whether you get in the program, or for companies that are already in the program, how you stay in the program. Now SBA is going to replace that narrative process. It may not be exactly what's in this proposed rule. This is still going to be out starting tomorrow for a 30-day comment, but very clearly SBA is going to change that process so that the narrative is not that individual social disadvantage. And the big emphasis in this proposal is showing discrimination against a group by a government or a private entity. So this is a bit different from saying, oh, there's cultural discrimination or there's social discrimination. This is you have to pinpoint discrimination from a federal or state or local government or a university or corporation. So in general, a government or a private entity. And that discrimination has to be within the applicant's lifetime. It says that the discrimination is within his or her lifetime by a federal, state, or local government or a university or corporation through a specific action. So that's another element. It's refers to an action, policy, rule, regulation, or other practice of any of the agencies, subsidiaries, or authorized agents. So this is very different from the narratives that people have been submitting in the past, where they might say, previously the narrative was, I used to refer to it as the three E's. You had some sort of discrimination in employment, education, or entrepreneurship. So employment, education, or business ownership. And now, if this proposed rule becomes final, you have to show that you are part of a group that has been discriminated against within your lifetime by a government or a private entity. There is an element of self certification of group membership, but in addition to that, so you have those three elements, plus you have to show material harm. And that seems to be specific material harm to the individual. It's referred throughout the rule as a citizen. It's always been the case that you have to be a citizen to get in the AA program. But so now this rule refers to the individual as a citizen. The citizen must establish that the discrimination, bias, or favoritism conferred material harm on the citizen. Talking about a very, very different structure than what SBA had before. You saw many people writing in narratives during this 3-year period, starting in 2023, of I'm in a particular industry that discriminates, say, against women or discriminates against people with disabilities, or that my industry in general is very unwelcoming to a particular race or ethnicity group. Here, now under this proposal, appears based on what I'm reading about, you have to identify a particular government or private entity that is engaged in discrimination, and it can't just be historical discrimination. It can't be from 100 years ago or so. It has to be during the citizen's lifetime. So those are the big changes here. Now, big question that's come out, does this apply to present firms that are in the program? If you are one of, I'm going to go over some of the stats later, but if you're one of the, say, 3,000 companies that are in the program, are you going to have to meet this standard? First of all, it's clear that this does not apply to entity-owned firms. That's in the title of the proposed rule. Reforms do not impact entity-owned firms. There's there's a there's a strange sentence where it says uh, SBA would not apply the new test to current participants at their next annual review. So you wouldn't have to do it at your next annual review, but it kind of suggests, does that mean that you would have to do it at the annual review after that? So maybe 2 years from now, are you going to have to go through that? SBA does seem to indicate later on in the document, if you go into the cost benefit analysis, there's a sentence that says this rulemaking does not affect participants currently admitted to the 8A BD program. Now, that sentence is not in the regulatory text itself. So it's not, I don't know that you could take it to court. Maybe you could. I mean, it is out of the word of SBA. This is something signed by the administrator. But first of all, it's not a proposed rule. It's not in the actual regulatory text, but there is this indication in the cost benefit analysis that the rulemaking does not affect participants currently admitted to the 8ABD program, suggesting that if you're in the program right now and maybe you could not qualify under this new standard, you're going to be able to remain in the program. It's not going to be like the post Ultima state of events where everybody had to reapply under the new standard after Ultima, that companies still remain in the program. But that would be a good area to submit comments in during this 32-day comment period, because otherwise it would end on a Saturday. So how is this actually going to work? SBA has made a big to do about them getting rid of the narrative that is not going to be an individual narrative. It does seem like there's still going to be a lot of writing involved in this. What might happen is that if you're a member of a particular group, and I'll name a few groups that I think might be able to get in under this standard, maybe there will be organizations, nonprofits, trade organizations, or the such that might be able to identify the necessary discrimination by a governmental or private actor to justify that group as a whole. So we still have this group basis, but then there's additionally the requirement that the citizen that applying establish material harm. And that part of it is not particularly defined. There's a lot in here about what sort of groups might qualify and how they would qualify, but the material harm is really just defined as loss of access to or diminished opportunities related to economic advancement. There's not the same level of detail that SBA used to have with those three E's of employment, entrepreneurship, and education. So you have less specificity on what exactly qualifies as material harm. The SBA gives some examples of how groups would qualify. You self-identify as part of a group, and their their first example is the previous rule, the previous social disadvantage rule prior to Ultima. They would say the prior iterations of this rule, 13 CFR 124.103, that excluded the citizen's racial or ethnic group as a group entitled to a rebuttable presumption of social disadvantage. So what they're really saying there, and actually it says somewhere in this document that under the previous rule, pretty sure it said it was impossible. Said under the previous rule, both the text and its application. This is a quote from SBA. It rendered white Americans almost totally unable to participate in the program. So SBA says that under the previous rule, because it had the five identified groups: Black American, Hispanic American, Asian Pacific American, South Asian American, Native American, it made it totally, almost totally unable to participate if you're white American. Um, I don't know that to be true. I know that there may be segments of white America that were not able to get in the program. But if you look at the statistics, there's a lot of service-able veterans that are in the 8A program, potentially because they applied under disability. I wrote a note at some point showing out the photos of people that appear to be white, and women were able to write narratives and get in. A lot of them saying, "Oh, I'm in an industry that discriminates against women." You know, there are not many women construction company holders, owners, and there are people of Jewish faith, Jewish Americans were able to get in. That was actually used to be one of the examples that SBA used to use on how you would be able to establish their social disadvantage. So I'm not sure that it's true that all all segments of white Americans were almost totally unable to participate. But that is the statement that SBA makes. And clearly, the example that SBA is thinking of when they're saying, here's a group that the prior version of this regulation excluded as entitled to a rebuttable presumption of social disadvantage. But that's not the only group that was not in that list of five, by the way. It's not just that white Americans were not in that group of five. When I was at SBA, there was some movement to include persons of Middle Eastern, North African descent, MENA, particularly because post 9/11, there was, I'd say most people would agree, there was clearly discrimination against people of Middle Eastern, North African descent. Some of that still exists today. And so that's another group that was not under the rebuttable presumption, Middle Eastern, North African descent, that could potentially qualify under the SBA example. Additionally, you have to point to specific government or private entity actions. So there, one thought that came to mind is the countries that are on the travel ban. There's a lot of countries now that are under a travel ban, and that is a government action. Now you'd have to make a showing about the material harm to the individual and show the discrimination. So that may be hard case to make now, but maybe in the future, you could say, well, in 2024, 2026, 2025, this country was under 2025, 2026, this country was under the travel ban, and I was in, I have that, I identify as a person of that origin, and that was a government discrimination against people of my nationality. So I think this move covers more than just white Americans, as the proposed rule suggests. Uh, it, it also the fact that it's pointing to the exclusion of the companies that were entitled to rebuttal presumption does give kind of a strange vibe of these folks that were in that list of five. They got these contracts. Less than 50% of the program, by the way, because entity owned makes up more than 50% of the program. But they they got 8A contracts, and now we're going to push them from being the favored group in favor of everybody else that was not in the rebuttable presumption. And we're trying to get those contracts back. Now, that's not what SBA say. I'm not trying to put words in their mouth, but it does kind of give this strange vibe of, well, this previous classification had these favored groups. We're going to kind of switch it around to say, oh, if we are not in that favored group, now it's your chance to get in the program and benefit from all the elements that make the 8A program successful, sole source contracts, 8A stars, that sort of thing. So the big areas of comment, I think, will be how do you actually justify this? What's the effect on people that are in those uh, rebuttable presumption groups? Is it basically impossible now for them to get in? Another question that comes to mind too is what about folks with multiple heritages, people of mixed race. Now the actual wording of the regulation seems to say if you are a member of this group or not a member of the favored group, you can use that identity to qualify for social disadvantage. So what if you're both at the same time? The or seems to mean, oh, you actually could get in under having mixed race heritage. So some comments will deal with some of the specifics. It may deal with this vibe of, okay, we had some people that were favored. Now we're going to go the other way and say that everybody that was not in the rebuttable presumption groups now gets in favor. And then I think the big question will be: is SBA going to apply this to current firms? There's a not entirely clear. They probably want a more clear statement from SBA that it's not going to apply to current firms. That there is that sentence in the cost benefit analysis that says it will not apply. It does not affect participants currently admitted to the 8ABD program. But then there's also the statement earlier on that it's not intended to apply to current participants at their next annual review. So that's not particularly clear because that means, oh well, you could change your intent, but also, what about after that annual review? You could have something else happen there. Let me answer a couple questions in the chat before I move on to the next topic. This will be available on demand later. It'll be on YouTube and on Substack. I'll send it out by email to all the subscribers. Kevin H. Notes that this was discussed at the National Small Business Contractor Association regional conference yesterday in Alaska. Seems like a lot of people are there at the conference. I've heard it was sold out. Sounds like people are having a good time there. And that one of the big takeaways was hearing that delays in approving new 8A applications was connected to the new proposed rule, and SBA saying they need to enforce rules already in place to ensure that only truly eligible firms are in the 8A program. So there, I'll be going over the stats later, but just to give you a preview, I think we're at 299 days now since SBA last approved an 8A application. The last 8A application still was approved August 15th, 2025. There's a website, 8afacts.org, that's puts a counter up, says, here's the number of days since the last applications. Like, here's the number of days since the last accident. Here's the number of days since the last application. Where I think last I checked it was 299. So tomorrow, if they don't approve an application today, it'll turn 300. We'll have 300 days since the last application. And Kevin's suggesting that that's because of this rule. Now, it's still a proposed rule. It's not a final rule. So I assume if that's the reason that they'll continue this delay in processing applications while they get the reviews in. That also brings to my mind the question of, since this doesn't apply to entity-owned firms, why didn't they just approve entity-owned firms? It's every application that's been stalled since August of last year. So why not just approve the entity-owned firms? And then Michael as thoughts on applicants who have been waiting for their decision. New examples will need to be provided, or will be examples provided under old rules be honored. Well, gosh, that's a good thing to put into the comments. Based on what SBA did with Ultima, where they made everybody go back and get new narratives, I wouldn't count on them taking the stuff from your existing application because and I suppose you could say, "Oh, is that the time you apply?" But it's such a big shift. It'd be hard to approve people, under on the same administration that's putting in place these shifts. It'd be hard for them to say, "Well, we're going to approve you under the prior narrative analysis," especially when they made big deal about doing away with the narratives. All right, I do want to break some news here because the Department of War has been required to issue a small business bill of rights. This was from the National Defense Authorization Act of 2025, which was December 23rd, 2024. And they're supposed to do it within 12 months, but it's okay. They got around to it not too long after. Uh, and they published it online recently. I just kind of happened upon it, but I was referred to it. And uh, I don't know that they put out a press release. I haven't seen any coverage of it. The requirement from the 2024 statute was for DoD, DoW. We'll probably refer to them as DoW because it's called the DoW Bill of Rights. I'll call it the DoW Bill of Rights, and it authorizes the director of small business programs within DoW to establish a resolution process for small businesses to submit complaints, inquiries to DOW, and then have the Office of Small Business Program request assistance from the acquisition workforce to resolve those issues. So this is a very small business friendly move. It gives you another avenue to make your complaints known, particularly with the biggest buyer in the world, the Department of War. It also requires the same statute required the Department of War to inform small businesses of what rights they have under the Small Business Act, under the Small Business Regulatory Enforcement Act, the Ombudsman, how to contact components within DOW. So it gives small businesses all that information about how their different avenues are to make their complaints known to DOW. And lo and behold, the DOW has now published that Small Business Bill of Rights. Let's see if I can bring it up here. Here we go. Here is the page, the Small Business Bill of Rights. Now, you will note it says this program is not live. I think the first time I went to this, it did not have that, but they're very clear that they do not want people submitting their forms quite yet to DOW on the Small Business Bill of Rights. But the page is up. I'm sharing it here right now. It tells small businesses they can learn about their acquisition rights and report potential infringements. That's the important part. I mean, the rights, yes, good to have that all in one place. You can go to the SBA National Ombudsman, you can go to the Apex Accelerator, you can go to your Office of Small Business Programs under the industrial based office within DOW. But the important part is having this new resolution submission form. So it's not a complaint form, but you can think of it as a complaint form. You can go to this form and you fill in your SAM, your cage, your name, prime sub, and it does refer to it as a complaint. I assume if you submit this that you get another form to say what your actual complaint is. It doesn't seem to be up yet, but the idea is you would get this complaint and then the small business office of small business programs would then send it to the contracting office to get that complaint resolved. There are a few more components of the Small Business Bill of Rights. Here is the a glossary of terms. There's an executive summary of the actual Bill of Rights. There's the Article 1, so it's the same kind of structure as the Constitution. You have here, Article 1 is advocacy and assistance. Article 2 is fairness in contracting and agreements. You're entitled to transparent contracting and agreement opportunities. Article 3 is small business priorities and exemptions. You have priorities for American small businesses first and contract agreements and elsewhere. some exemptions. And here's the important part: the complaint resolution, the ability to raise concerns and seek resolution regarding regulatory compliance and enforcement. You can also challenge unduly restrictive solicitations and call for efficient and cost effective resolution of competency determinations, contract claims. Small business contracting is there. There's also a one pager on the site of the Small Business Bill of Rights. Very attractive graphic. It's actually 2 pages, but it looks really good. And here's those 4 areas again about the rights that companies have to submit their concerns. And here it says submissions are reviewed by DoW contracting and small business professionals. An important part of the law is that DoW has to submit reports to Congress and to the Secretary of War annually on the complaints they get through this process. So it's they're going to be tracking this. Congress is going to be tracking this. I do see this being a significant avenue for small businesses to get resolution from Department of War. Website says it's still not live yet, so we may see that in the next few weeks or so. But the website's up, the forum seems to be up, and they're almost ready to go on the Small Business Bill of Rights after getting it passed by Congress in 2024. Uh, up until this morning when SBA published the proposed rule, I was going to talk a lot about other SBA policy changes on tap. That seems to be less important now that we've seen the big policy change on the 8A program. But SBA just last week had put out to the White House Office of Information and Regulatory Affairs, OIRA, that they were going to finalize 2 policy changes. Uh, when you get something from OIRA, it doesn't really give you much detail. It just gives you the title of the policy change. And the 2 policy changes that SBA was sent to the White House for review were number 1, removing constitutional concerns from SBA programs, and number 2, rescinding unnecessary notice and comment procedures. These were both received by OIRA on June 5th, which was last Friday. OIRA has a 90-day review process, although it can go longer because there's still the proposed rule on fraud, waste, and abuse reforms that I talked about months ago. That's still on the tracker for OIRA, so that's been well more than 90 days at OIRA. What's interesting about these 2 submissions is that they're final rules. They're not proposed rules. So usually, just like they had with the 8A social disadvantage change, you usually have a proposed rule, then you have some period for comment with the social disadvantage change 30 days, and then you have a final rule. Here, with those 2 policy changes, SBA is going straight to final. How are they doing that? Well, they're probably using a White House memo that said that agencies can move straight to final on I think it's um, unconstitutional policies. So I can find the directing the it's called directing the repeal of unlawful regulations, April 9th from 2025. And basically said if something violates one of 10 Supreme Court cases, one of them is the Student for Fair Admissions case, another one is the Local Bright Enterprises case, then agencies can and should dispense with notice and comment and go straight to a final rule. It's hard to tell based on the titles of these final rules of what they're going to be. If you had asked me on Friday what it means, I would have thought, well, that's going to be the change to the SBA social disadvantage rule. It's going to be implementing the Students for Fair Admissions and saying we're taking the rebuttable presumption out. But SBA is going through notice and comment for that. They are using comments for that. So what the removing constitutional concerns from SBA programs means is kind of a mystery to me. I'll have to think about that more. Maybe there are other areas where there's racial ethnic preferences that they could go to. Maybe in the small disadvantaged business area, they could look at that. Although SDB just points to the 8A rule, so it seems like by changing it in 8A that you'd also change it in SDB. And then rescinding unnecessary notice and comment procedures. It seems like SBA doesn't want to go through comments as much anymore. They do have a rule 13 CFR 101.108 that says that SBA will use public participation requirements for rulemakings related to public property, loans, grants, benefits, or contracts. So maybe they're going to change that regulation and dispense with public comments for certain areas of SBA operation. That's pretty much all SBA does, right? So public property, loans, grants, benefits, or contracts. What else does SBA do? Maybe entrepreneurial development. But if you take out public comment from all those areas, there's really not much that you're getting public comment on. Let me talk a bit about SBA's news releases recently. SBA had announced a agency-wide reorganization. Let me put that up on the screen here. This was also on Friday. SBA announces an agency-wide reorganization to modernize, drive operational efficiency, and enhance accountability to taxpayers. And you go down to what they actually did. It looks like they're centralizing many different functions into particular offices, centralized disaster related functions within the Office of Disaster Recovery, centralized data analysts, economists, grants, and acquisition professionals in the CFO office, centralized IT professionals within the CIO office, human resource professionals within human capital office, attorneys and paralegals within the Office of General Counsel. I was in the SBA Office of General Counsel at one time. That maybe there were a smattering of attorneys outside of that office, but for the most part, I think they were already within the Office of General Counsel. To me, the biggest point here within this press release, well, actually, I think the biggest point is SBA says that they've reduced their workforce by over 50%. If you remember back in April of 2025, SBA said, we're going to start reducing our workforce. And they gave a percentage on how much they wanted to reduce their workforce. It was not 50%, it was 43%. SBA said, we're going to reduce our workforce by 43%. So the fact that they're now coming back and saying that they reduced their workforce by over 50% means that they overshot the amount that they were intending to reduce. So maybe more people took the deferred resignation program, the DRP, than they had expected. Maybe more people just took early retirement or other opportunities, but they actually overshot that 40%. They reduced their workforce by over 50%. So that's the biggest news coming out of this news release. The second is the fact of the data analysts and economists going into the office of chief financial officer. And this is just significant within government contracting because there are economists in the SBA Office of Government Contracting and Business Development, and they're apparently going to move outside of that office. Why are there economists within the Office of Government Contracting and Business Development? It's because of size standards. The economists within the government contracting office work on size standards. They actually published a size standards rule in August of last year, a proposed size standard rule for revenue-based size standards. It was going to change things like engineering. It was going to bump up engineering services size standard. It was going to bump up a few other of the size standards as well. Consulting was another one that was addressed in that proposed rule. And the economists work on that size standard. Now they're moving to a different office. That would suggest to me that the size standard proposed rule is going to take a long time to go to final, and maybe we'll see another proposed rule before we actually see a final rule. So that fact that economists are on that list indicates to me that well, we're going to be waiting a long time before we see more out of SBA on size standard. Uh, uh, One more SBA news release I wanted to bring up, and this one deals with service-able veterans. This was from the Office of Inspector General yesterday. The SBA Office of Inspector General said that they had gotten to a settlement with a couple of uh, businesses that received service-able veteran-owned contracts. The businesses were named Broadway Electric and Cornerstone Contracting. And those two businesses, as well as a CEO and president, agreed to pay $21.3 million to resolve False Claims Act allegations about obtaining service-able veteran-owned small business contracts. It seems like the scheme here was that there were service-able veteran-owned firms that were legitimate firms, probably certified firms, that were put forward to win contracts. VAs involved, so probably VA contracts. But then the work was actually performed by these firms. It says Broadway and Cornerstone personnel, in fact, primarily controlled execution, staffing, and financial administration. The individuals were not service-able veterans and were not qualified to own or control service-able veteran-owned businesses. This case, which ended in this $21 million settlement, was brought by a whistleblower. I think there's a point in here where it says the firms. Oh, here's at least one SDVOSB owner raised concerns regarding compliance with federal control and participation requirements, but the defendants did not implement material changes to the structure or operation of the arrangement. So, meaning the serviceable vet-owned firms that were put forth as qualified weren't doing the work. They weren't complying with the limitations on subcontracting and the anti pass-through rules, maybe non-manufacturer rule as well. But they raised those concerns to these companies, and they were not heard, and that ended in this $21+ million settlement. Now, when I was at SBA, the big scheme was the rent-a-vet scheme, where you'd have a company where the people behind the company were not the veteran. They'd put a veteran as a figurehead, but the veteran really wasn't doing anything. This is a bit different from that. This sounds like there were actual independent companies that were put forward, but they would participate in the scheme. They'd get some percentage of the work, and they pass on all the work to Broadway and Cornerstone. It ends in this $21 million settlement. It'd be interesting to see what the total value of the contracts was. I don't think I see that in this. It's a long running scheme, April 2017 through May 2025. So just to the end of last year. It's $21 million. The total value of those contracts is some percentage of those contracts. It does state that there are relators under the False Claims Act. You can have relators. There were two whistleblowers in this case, a veteran of the United States Air Force, an executive with an SDVOSB firm, and they will receive $3.6 million from this settlement as relators in the False Claims Act case. There are a number of important court cases and GAO cases that have come out recently. I'm going to go through some of those. There was a court of federal claims case about the Mentor-Protégé program, and it follows on a previous SBA OHA case. It made a bit of an impact in the industry because it affects the timing of under which mentor-protege joint ventures are qualified to bid on contracts. So in this case, the case is called Primary Healthcare. Primary Healthcare was actually a joint venture between a mentor and protege in SBA's mentor-protege program. And parties, uh, the mentor and protege, terminated their mentor-protege agreement. They notified SBA that a mentor notified SBA that it was going to terminate its mentor protege agreement, but the joint ventures between the firms still continued to exist. So they terminated the mentor protege agreement, but they still had the joint venture. And at the point that the companies terminated their joint venture agreement, they had already submitted a bid on a contract. Then after they terminated the mentor protege agreement, that bid required a final proposal revision. So maybe the agency asked for discussions and got a new agency here with Defense Health Agency. They got a new proposal from the company. So the question here is, when do you have to have your mentor protege agreement in place? If you ask someone, if you ask me 6 months ago, you ask most lawyers, when do you have to have your mentor protege agreement in place? The answer would be before you submit the proposal on the contract. The general rule has been, or at least the general advice has been, you have to have your mentor protege agreement in place before you submit your bid on the contract, and you have to have your joint venture agreement done and finalized before you submit your final proposal revision. This case says, wait a second. You also can't terminate your mentor protege agreement between the original offer and the final proposal revision. So it basically says you need to have your mentor protege agreement in place both before you submit your bid and before your final proposal revision. So the primary healthcare here, they were excluded, or I think they lost a size case at SBA. Yeah, they lost the size termination at SBA, and then ultimately an OHA decision. because the company had terminated the mentor-protege agreement after offer, but before the final proposal revision. And the Court of Federal Claims upheld that decision. Now, the company gave a couple of arguments to say why it should still be qualified, even though it had terminated the mentor protege agreement. Number one, it said this is just a check the box exercise. And to that, the court said, well, SBA has the rules. They say their rules require final proposal revision. That's what the judge said at SBA. So even if it's check the box exercise, that's the rule. You have to turn square corners. You do have to check the boxes in order to win the contract. Their number two argument, primary healthcare, was that SBA has allowed this in other cases. They've allowed firms that have terminated or even graduated from the mentor protege program to win contracts where the termination occurred after offer but before final proposal revision, and SBA is being arbitrary by not allowing it here. And there, the court says, well, if you look closely at those cases, those are old cases. SBA changed its regulations in 2020 to require compliance as of the final proposal revision. And those cases are from pre 2020. There's one in 2019. Uh, there were different regulations in place at that time. So you can't use those old cases to interpret a regulation that came in place in 2020. And then there's an argument that SBA's interpretation is unworkable and potentially manipulable. So the primary healthcare said you could try to draw this out so that your competitors have expiring mentor protege agreements. The biggest impact of this is if your mentor protege agreement expires, because your mentor protege agreement can expire within 6 years. You can extend it another 6 years, but it's going to expire at some point. And if you're in the middle of a bid, then you can't control whether the agency is going to ask for final proposal revisions. You could be out just by based on that expiration of the mentor protege agreement. So the company puts this point up that the mentor using this rule creates a lot of risk for mentor protege joint ventures because they could have their agreement expire during the solicitation phase and then have to submit a final proposal revision before that. But the court says, "Okay, that may have merit, but the court's role here is to apply the law and interpret regulations, not take sides in the policy debate." So basically, go complain to SBA about this manipulation, this unworkable reg. Don't come to the court for this. So, kind of a surprise to people who have been working in the mentor protege area for a long time. This case says you have to have your mentor protege agreement in place as of the final proposal revision, not just when you first bid, but also when maybe after discussions you submit a new proposal to get award of that contract. It doesn't mean that you have to have it in a contract, so I wouldn't take it that far. Maybe and we've seen some VA cases that have been surprising on that matter with service able vet status, but at least you want to keep it around for long enough so that you get to the final proposal revision. There's another Court of Federal Claims case that I'll mention. It's called International Business Sales and Services Corporation. That's also about the mentor protege program. This is really interesting, just the facts of it, because it's another mentor protege agreement gone bad, where the mentor terminated the mentor protege agreement. The mentor and the protege had a falling out, and their joint venture had won a multiple award contract. And after the mentor left the mentor protege agreement, the agency, NOAA, novated the contract to the protege. And the mentor protested that, which is interesting in its own right. The court says you can't protest that because you didn't actually bid on the contract. Even though you're part of the joint venture, your name is not the name of the company that bid on the contract. So you don't have standing. You're not an interested party to bid on this. There was another protester in this case as well that won the contract. It's a multiple award contract. So you have several different companies that are on this. That company that won the contract also was not interested party. It was found to not have standing because it won a contract. So it can't both win a contract and protest the contract of another company that won. That same reason would also seem to apply to the mentor too, since the joint venture won the contract and the mentor was part of that joint venture. Maybe they could protest innovation, but the court says innovation is a matter of contract administration, not a matter of contract award. But just the facts alone, the fact that the mentor is going against the joint venture is an interesting scenario that I haven't seen before. That was the International Business Sales and Services Corporation case. Uh, One case out of GAO, there was a case called ID8 Spark about subcontractor past performance, joint venture past performance. We've seen a number of these subcontractor past performance issues or affiliate past performance issues come up at GAO and Court of Federal Claims. This case stands for the principle that an agency can, if it wants to, ignore the experience of a subcontractor joint venture. So in this case, the uh, Offeror ID8 Spark had a subcontractor that is a small business joint venture, and a member of that joint venture was on a previous contract. They tried to use that previous contract as their past performance, and the GAO said the agency can ignore that for a couple of reasons. Uh, First of all, that past performance is not of the prime, it's of a subcontractor. And also, the prime was not in the joint venture that is trying to get the contract. It says it's a bit convoluted because there's so many redactions to this. It says even though the quotation did identify deleted as a joint venture of deleted and deleted, that would be a subcontractor to ID8 Spark, not ID8 Spark itself. And this is under an SBA Rule 13 CFR 125.8E, which says if you're bidding as a joint venture, the agency has to take into account the work of the past performance of the members to the joint venture. So if that joint venture had bid on its own, then it could potentially have used the past performance of its members, but not here where ID8 Spark is the prime, is not the joint venture that's trying to use that past performance. So another case where the agency is able to exclude or ignore the past performance of a subcontractor. Some updates on the FAR overhaul. Also, last week, lot happened at the end of last week. Uh, the White House OIRA office gave the green light to publish a number of proposed FAR rules, so we'll probably be seeing that in the next couple of weeks. It's a lot at one time, so I'm sure there's a lot of formatting that they have to do behind the scenes to get this out, but it's a lot of the FAR overhaul that will be coming out. We've got 1, 2, 4, 5, 6, 7, 10, 18, 24, 26, 29. 33, 37, 39, 40, 41, 53. All those parts were cleared to go out as proposed rules. Remember when the FAR overall first came out, it was under class deviations. Essentially, they published it on a website. They published it on a website, asked for comments from the public through a website forum. It's not through the official notice and comment process. Now they have to go back and put it through the notice and comment process, uh, which is proposed rule, comment, final rule. So the proposed rule for all those parts that I just mentioned, I don't know, what was that? Maybe like 15 parts? Probably more than that, actually. 6, 7, 13, 16, maybe 16, 17 parts. Those will be coming out as proposed rules in a number of weeks. Part 19, which is small business section, that hasn't been cleared by the White House office yet. That says OFPP is reviewing that. So it still has to go through Office of Federal Procurement Policy and it has to go through Office of Information Regulatory Affairs. Oh, I missed some that are on another page. 3 and 49 are also cleared to go out. So probably up to about 18 parts there. 1, 2, plus 5, 10, 12, 15, 19. I think I got it this time. 19 parts that are clear to go forward to proposed rule that we'll probably see in the next couple of weeks from the FAR overhaul. And then we'll see whether it's 30 days, 45 days comment on it. I mean, if they're all going to publish them at the same time, it seems like 30 days is pretty fast. to give comments on 19 parts. I don't know if they'll stagger their proposed rule, but all of these were approved by the White House around the same time. Okay, quick update on 8A numbers. Haven't done this in a while. Just seemed like not much was happening, and I sort of fell out of practice on doing this. But I was tracking all the 80 numbers for a while. So if you're following online, I'm looking at the number of active 8A firms according to 8A SBA's database. You start out in January of this year at over 4,333 before SBA starts the data call, starts suspending firms. Then it drops to about 3,200. Over 1,000 firms were suspended for not responding to the data call. Some of those firms got back in because they responded to the data call, but then it drops again because SBA suspends and proposes for termination over 200 firms for economic disadvantage. And so you're back down to 3,200. Some of those firms get back in because they established that they are economically disadvantaged. So we're rolling along at 3,300 or so for a while. Then it does go up again as some of these firms get off the suspension list and more firms are getting their data call information in. So we do get back up to 3,400. But guess where we are now? As of today, when I last looked into the SBA database, we had fewer than 3,000 8A active firms, 2,981 firms. This is a result of firms naturally leaving the program. It's 10-year program. So they're firms that are graduating every day from the program, but there's no firms coming in to backfill them. I talked about this with Jackie Robinson Burnett on the podcast last week. The firms that are leaving aren't having more firms come in behind them. So you're seeing at least a tenth of the program leave every year. And so now those firms are naturally leaving. Firms have also withdrawn from the program under pressure of suspension, or just because they see the writing on the wall. The 8A program is not as effective as it was previously. So there are many firms that have withdrawn, and now we're under 3,000 8A firms, 2,981, at least based on the data that I saw at SBA today. Let me just check the chat to see if we got anything else. We saw the another comment from Kevin H that the mandatory SBA HQ review of all annual reports is resulting in rejection of waivers for good faith efforts to meet BAT targets. That's a good point. I've heard that as well. BAT stands for Business Activity Targets, requirement that firms in the 8A program in the second half of their participation in the 8A program have to meet benchmarks on getting work outside of the 8A program. If they don't meet those benchmarks, the consequence is they're not able to receive sole source contracts from the 8A program. And previously been the case that SBA would allow you to show good faith efforts. You were going after contracts. You had these efforts to go after contracts outside of the 8A program to show that you weren't dependent on the 8A program. But according to the comment in the chat from Kevin H, the SBA is reviewing the annual reports and it's resulting in rejections of those good faith effort reports to meet the business activity targets. So putting more pressure on firms in the 8A program to stay in the program and benefit from the program. Oh, we're seeing a lot from SBA. Just to recap, proposed rule coming out tomorrow on the presumption, removing the rebuttable presumption of social disadvantage from the 8A program. Comments will be due 30 days, so they'll be due July 13th, since July 11th is a Saturday. And then much more coming up in terms of final rules from SBA. You'll see the FAR overhaul proposed rules come out very soon. And then we still have some congressional news too. I'll be talking with a podcast guest in the next couple of weeks about the rule of two, as well as some of the action around the women-owned program and the certification programs generally. So a lot happening in small business GovCon. Again, thanks for joining GovCon Intelligence, and I will see you all again soon. Thanks.